The lecture is going to talk about the extent to which trademark law should focus on purely making empirical assessments of certain core issues or questions. The core issues or questions that this comes up with normally are distinctiveness and likelihood of confusion. And one of the things that I think you see if you read a lot of trademark law, at least in the States, is that the courts think that all they're doing is making empirical assessments. And I think very often they're engaging in quite a lot of normative work, and it would be a lot better, and trademark law would be a lot more balanced and more open, and we'd be able to develop it in a lot more intelligent ways if we acknowledged that what we were doing was normative as well as empirical. I'm not suggesting we sort of abandon empiricism, we need it, but we just need a lot more normative. And the problem at the moment is that most scholarship and maybe some courts are going in the opposite direction. So one impulse that a lot of scholars have had recently in response to concerns that our methods of making empirical assessments are inadequate is to say, look, we can make our empirical assessments a lot better just by improving the way we measure things, by looking at what people have told us about psychology of consumers. And so why do we do that? And that will solve the problem. We just get our measurements better. That's the problem. I think that may not be harmful. It could be harmful, and I'll talk a little bit about why it might be harmful, but I think it's sort of missing the point. To me, the bigger problem is relegating the normative questions to purely empirical, and the courts are a bit wanton to do that. And so one big example in the last year and a half is the Supreme Court decision in Booking.com, where Justice Ginsburg essentially discounted any policy concerns other than consumer association. So there was this survey that said 75% of consumers thought Booking.com was a trademark. End of story. It's a trademark. It gets registered. In contrast, Justice Breyer, who was the only dissent, it was an A1 decision, said, look, there's a lot of competitiveness problems I have of giving control over Booking.com to one travel reservation website. What if someone else wants to use Booking to book something? And we need to take that into account. And the problem is, if you think that the whole game is about an empirical measure, when 75% of consumers say they identify Booking.com as a single source, then it's distinctive. And so all those competitiveness concerns that Justice Breyer wanted us to think about go out the window. So that's the essence of the problem. I discern, however, that it's not just a recent phenomenon that Booking.com has brought to the fore. If you go back and look at a lot of our case law on distinctiveness and confusion, you find that there are normative analyses built into the doctrine, but they're never raised to the surface, or rarely raised to the surface. So for example, in distinctiveness, we clearly do think about competitiveness. But in the confusion inquiry, because of our fascination with surveys, which makes us think we can identify the truth, the real facts, and then we just sort of apply a neutral body of law and we have an outcome, there is a lack of any real normative engagement, even though there are huge contested policy questions that have been essentially silently decided by courts under cover of an empirical analysis. So, post-sale confusion, dilution, effectively granted by post-sale confusion, is a way of protecting the premium brands and creating artificial scarcity. And maybe that's a good thing. If you're general counsel of Louis Vuitton, I'm sure that's a very good thing. But there's at least a decent policy debate to be had as to whether it's socially desirable that we, create luxury goods and put them out of the reach of ordinary people, or whether that actually, in some way erodes the social fabric. I don't have a particularly strong view one way or the other on it, but we never discuss it. But it's being done, that policy shift is being done under cover of saying consumers are confused. And when you do it under cover of the empirical question, you avoid any of the real discussion of the debates. So what I'd like us to do in trademark law is to become more normative, not necessarily to jettison all empiricism. That's not possible, it's not desirable, but to become more normative. And if we do that, I think we'll get a body of law that's more respectful of the variety of different policy concerns that come up, whether it be artistic creativity, whether it be competition, whether it be speech, political criticism, all of these can be more easily accommodated if we're willing to be open about making trademark law a much more normative endeavor. It's not the first time I've been to Singapore. I've a number of events here, both at the university and conferences in town as well. So my impressions are somewhat formed by this trip. This has been short though. And also by prior trips, because I was here for a month teaching now 5 or 6 years ago. First thing is I love this sounds strange, I love the climate, which may seem very odd. Most people wouldn't identify that, I think, but it's such a change from where I normally live. Chicago had snow a week ago. It was just so nice to be able to walk out in a little bit of heat. That was pleasant. The food is wonderful. It is a challenge to my palate. You know, I grew up in Scotland, and the food was less adventuresome than in Singapore. It was a step up for me to go to the States. I eat a lot more than I did 35 years ago, and coming to Singapore pushes my boundaries in a whole bunch of other interesting ways. So I love that. People are immensely friendly, and I've always found that there's a pretty intense engagement on ideas without being nasty, without being aggressive. It's always polite, but it can be really insightful, and I'm hoping I'll get that later today as well.